Hi everyone, welcome back to our channel. As promised, we will be discussing about the Building and Construction Industry Security of Payment Act, also known as the SOPA today. This is an important act for anyone in the construction industry. We will be breaking down on what the SOPA is, why it matters, and the pros and cons of the SOPA. To put it simply, the SOPA is a game changer in the construction sector. It's designed to ensure that contractors are paid promptly for the work that they have done. This act was introduced to address the issue of delayed payments and payment disputes that often arise in the industry. As is often stated, cash flow is the lifeblood of the construction industry. Delayed payments can cause a ripple effect of financial strain throughout the entire supply chain. The SOPA aims to mitigate such effects by providing a legal framework that enforces timely payments. The SOPA applies to a wide range of construction-related contracts, including construction works, supply contracts, and even consultancy agreements. One of the features of the SOPA is that parties to a construction-related contract cannot opt out of the SOPA. This is necessary in order to safeguard the contractors' or professional consultants' interests and help to ensure that contractual payments are made promptly for the work done. Before we elaborate on the pros and cons of the SOPA, we will explain some of the terminologies used in the Act. First, the claimant. This is the party who is entitled to be paid for the works done, or the services rendered, or the goods supplied. Second, the respondent. This is the party who has the obligation to make payment under a contract. This is usually your main contractor or your employer. Third, the adjudicator. This is a neutral third party who is appointed to decide on the merits of a claim lodged under the adjudication process prescribed in the SOPA. There are several advantages when referring a potential dispute for adjudication under the SOPA. The first and probably the most distinct advantage is that it provides a speedy resolution for construction disputes in comparison with other modes of dispute resolution such as court or arbitration proceedings. Disputes under the SOPA can often get resolved within a month from the time the adjudication application is filed, while court or arbitration proceedings can potentially take far longer to resolve. The second advantage is that because it provides for a speedy resolution, the legal fees and the associated expenses involved under the SOPA are usually significantly lower than the legal fees and arbitration costs which one may incur for court or arbitration proceedings. Third, if a claimant is successful in the adjudication determination is binding on the parties, albeit on a temporary basis, pending conclusive determination in court or arbitration proceedings, as the case may be. Failure to pay the adjudicated amount will entitle a successful claimant to register the adjudication determination in court and enforce it as if it was a judgment, and may also allow the claimant to suspend works on site pending receipt of the payment. Fourth, it may also be noted that the SOPA also renders pay when paid provisions in a construction contract unenforceable. Generally, this means that a main contractor, for instance, cannot, by contract, provide that a subcontractor is entitled to be paid only when it is paid by the employer. This similarly facilitates prompt payment for the contractor. However, there are some disadvantages under the SOPA as well. The first being that because of the short time frame in which an adjudicator has to decide the merits of a claim, an adjudicator will not have the full benefit of a trial or the opportunity to test the credibility of the evidence before having to make a decision on the claim. In view of this short time frame, it also means that the party's preparation time to address the claim fully is also compressed. The second point to consider is the upfront fees and deposit to be paid to the Singapore Mediation Centre when the claimant lodges the adjudication claim. This is to account for SMC's fees and the adjudicator's fees, and it is capped at 10% of the claimed amount. Such sums may well exceed the monies payable to commence a court action, especially when the quantum of the claim is small. a claimant who wants to get paid through the SOPA regime would have to pay for such costs first. However, depending on the outcome of the adjudication, such costs may be recovered from the respondent. The third disadvantage is that not all construction disputes are suitable for adjudication under the Act. Typically, construction claims for work done, including variation claims, will be suitable for adjudication. Due to the short time frame, it is difficult for an adjudicator to decide on more complex claims, such as those involving delay, prolongation, or acceleration claims, or other claims for damages. You should consult a lawyer for advice if you are unsure whether your claim is suitable to be raised in adjudication proceedings under the SOPA. To sum up, this statutory adjudication mechanism for contractors is very useful in resolving most construction disputes involving claims for work done or services rendered. The speedy resolution means that a contractor, if successful in the adjudication, can expect to be paid quickly while the works are still ongoing, so that they will not run into cash flow problems during the course of the project. That's all for today, and we'll see you in our next episode.